We're here on plaintiff's objection to, plaintiff is Mr. Corby, his objection to the child support recommendation. Mr. Corby, I've received your one-page, I've received your objection to the child support review. It contains an addendum. I've read all of those, so go ahead and argue your objection, sir.
I just, like it says in my form, I've had full physical custody of my son for 11 years now, and I've paid for all of his medical expenses, dental expenses, sports utility, anything he's ever needed. And, and recently we switched to 50-50 custody and everything's been fine. And throughout the years, I've got minimal child support. I was getting around $125 a month. And I was paying $500 in daycare expenses for the 10 years that, I had the full custody and before he was 12. And I just assumed that once we went to 50-50 custody that there wouldn't be any child support because I
know what they say about assumptions, right?
Right. But me and my wife just spent $6,000 for my son's braces and everything else. And I just seems like, we've put in a lot over these years, and for my son to be 13 and now to pay $391 a month just seems like a lot, I guess.
I'm not disputing anything that you've told me. However, I'm only allowed to make changes to things where there's a legal objection. So the only question that I have before me is, did the friend of the court accurately run the child support formula guidelines? And is there some number that they used that was inappropriate? I can't rectify past inequities. I can't change what happened in the past. So I apologize to you for that. I know that it seems in a world of fairness that might be a great argument, but all I can do is look at what is the current set of facts, set of circumstances. Did the friend of the court's office properly apply the formula? And if so, I have to go with that. That's what the law requires me to do. So the fact that you've made all of those payments, I'm taking as absolute truth, but I can't do anything about that. Does that make sense to you?
Yes. Yeah.
All right. So go ahead. Okay. Any other arguments that you wish to make?
And me and my wife are, we're also homeowners. So, we have home taxes and home expenses. And, after this winter we're going to have to probably put a new roof on after the ice damage and everything else. It just seems like being homeowners and everything else, we have a lot more expenses maintaining a home than income-based apartment building, where my electricity is paid for and stuff like that, I guess.
Well, the electricity is paid for by the rental. That's all in the costs. So the law doesn't let me say you get so much deductions for certain expenses. It's based on what your income is from both families, both sides of the equation. And as long as the income information is, we don't tell you what kind of house that you have to buy. If you want to go out and buy a very small, tiny house and live in that, that's entirely up to you. If you want to buy a mansion, that's entirely up to you. How you use that income is entirely up to you. And I can't get into changing that. So I recognize that what you're telling me is true, but again, I'm limited in the law by what I can effectively change. And so the question is, did the friend of the court use the guidelines appropriately? And the amount of expenses that you have is not one of those things that they have the ability to view or change.
Okay. Yeah, I guess, and I guess the only thing I can dispute about the income is that in the beginning of December, my son told me that his grandma moved in to Miss Ebner's house. So I feel like that's a change of income. And
the income, the only applicable income is the income of the two parents. It's not it's not the household income. Like if you had someone, a friend of yours or a cousin or someone that made a lot of money move into your home, I could not add their income to yours.
Right. But I mean, Miss Sevner could increase her own income by rejoining the workforce, and and
I can
because the
certainly
judge,
ask the friend of the, I can ask the friend of the court what they use for that. I see a number down here as a gross income, and I believe that was imputed to her or was so, but I'll ask the friend of the court. Ms. Ellison, who should I talk to about that?
That would be me, Your Honor.
All right, Ms. Kraus, can you tell me the income that was used for Ms. Sevner, the $1,417 a month? Where did that figure come from?
From Social Security.
Is that the equivalent of full-time work, or is there a process by which we could add to that for imputation up to full-time work?
If she has the ability to earn additional income because it's SSDI, she would, but we are not aware if she is able to work at any capacity outside of what she's earning now with that.
All right, so because she's on SSI, she is deemed to be disabled and not able to work, so that you are not able to impute any additional funds. Is that what you're telling me?
Unless she can indicate to us that she is able to earn an additional amount without losing those benefits.
All right, Mr. Corby, does that answer your question?
Yeah, yep.
All right, any other objections that you have, sir?
Nope. No, not really. I guess none of my arguments really make any, really don't have any credible dispute, I guess. So.
Yeah, and I understand your frustration, and I understand where you're coming from, but unfortunately, with this sort of situation, I am limited in what I can do for you. And unfortunately, none of the arguments that you bring forward are going to change what the recommendation is. So I'm going to have to deny your arguments, and we'll go forward with the amount as recommended. If something changes in the future, or if you get additional information, you can always bring that for us again.
Well, and I was just curious. So, do I still have full physical custody of my son?
That has not changed. The child support does not change custody. So all we're here today on is the child support.
Okay, and
So
as far as
order,
my son gets a percentage of Miss Sevner's disability amount, and it goes directly into a savings account for him. Is that going to stop for him, or is that?
Nope, that doesn't. This does not change that.
Okay. Okay, I was just curious.
All right. Anything else, sir?
Nope, that pretty much sums it up.
All right. The friend of the court will enter an order. Help me out, Ms. Krause, if I'm incorrect, but the friend of the court will enter an order indicating that the objection has been denied and that the child support amount, as recommended, will become the order of the court.
Correct.
All right. Thank you very much, Mr. Corby. That's all for today then.
All right. Thank you.